The stability of a great republic is secured not by its armies alone, but by the quiet, abstract power of its impartial justice. When the machinery of law ceases to operate in pursuit of truth, and instead becomes a brutal instrument of political vendetta, that state has embarked upon a course of strategic suicide. We are now witnessing this self-destructive spectacle in the courts of the United States. The reports of a grand jury repeatedly refusing to indict a high-profile political enemy, despite the relentless, almost obsessive pursuit by the executive branch, must be interpreted not as a partisan victory, but as a stark, existential warning. The American system, founded upon the separation of powers and the sanctity of the rule of law, is consuming itself. This act of institutional cannibalization is visible to all our rivals, who now observe the predictable, final stage of a once unshakable hegemony dissolving into internal anarchy. The modern great power is defined by its capacity to administer justice without prejudice. This is the essence of reliability and the foundation of global commerce. When an administration dedicates vast resources and 3 successive attempts to prosecute an avowed enemy, with charges that multiple grand juries have rejected, it sends an unambiguous message. Justice is now a political instrument. The prosecutor's role to seek justice, not merely convictions, is perverted into the role of a political assassin. This substitution of ruthlessness for impartiality fundamentally alters the governance model of the United States. It replaces the long-term, predictable stability of a legal framework with the short-term, capricious will of a single, vengeful leader. The world sees this, and the world is already calculating the risks of dealing with a state whose legal system is merely a subordinate arm of its political campaigns. This is the geopolitical cost of political vindictiveness. The grand jury, composed of citizens, is designed to serve as the conscience of the community, the final, essential shield against state overreach. When this conscience repeatedly refuses to assent to the state's demands, issuing a no bill not once, but thrice, it signifies a profound failure of the executive's legal case and, more critically, a catastrophe of public consent. The executive branch may possess the theoretical power to bring a case repeatedly, but the practical moral authority is annihilated after the first, let alone the third, rejection. The grand jury's defiance proves that even ordinary citizens recognize the baselessness and vindictiveness of the prosecution's intent. The repeated failure to persuade the very community whose interests the prosecution is supposed to protect is the most damning internal judgment possible. It signals that the government has lost the moral mandate necessary to conduct its domestic affairs, let alone its complex foreign policy. The use of unlawfully appointed prosecutors, individuals without the lawful authority to even set foot in the grand jury, is a visible symptom of a deeper systemic rot. The desperation to bypass established institutional rules to bring in an unqualified figure from a distant jurisdiction because no local, experienced federal prosecutor would touch the case is the hallmark of a regime that has prioritized loyalty over legality. This willingness to compromise the procedural integrity of the most powerful legal office in the world for a political hit confirms that the system's protective mechanisms are being actively disabled. This rot travels far beyond the courtroom. When an administration demonstrates such contempt for internal procedure, it signals to every hostile foreign intelligence service that American institutions are now compromised and chaotic. The history of prosecutorial misconduct in this administration is not a series of unfortunate errors. It is a pattern of deliberate policy. The findings that a prosecutor ran roughshod over the rights of the accused, presented incompetent evidence protected by privilege, and attempted to violate the constitutional guarantee against self-incrimination, prove that legal ethics have been wholly abandoned. This conduct documented in transcripts and judicial findings is the unraveling of institutional trust. Trust is the invisible glue that holds a legal system together. When lawyers for the government are proven to have acted unethically and unlawfully, the entire body of the law is stained. This corrosion is a strategic disaster, as it legitimizes the cynical view of law held by autocratic rivals and undermines the core value proposition of the American model of governance. To the rest of the world, the relentless, obsessive pursuit of a single political enemy, a campaign that continues after 3 failures, and the public revelation of misconduct is not simply a legal error. It is a massive misallocation of national strategic capital. The time, resources, and intellectual focus of the Department of Justice are finite. Every minute spent on this evidence-free political vendetta is a minute not spent prosecuting genuine transnational threats, foreign intelligence operatives, cyber criminals targeting national infrastructure, or international money laundering operations that threaten the stability of the global financial system. The political obsession of the executive is actively disarming the legal capacity of the state against real, strategic threats. This transfer of focus is, in the harshest sense of realpolitik, a direct strategic gift to the nation's adversaries. The revelation that the president himself is alleged to have committed the same exact crime, mortgage fraud, that his subordinates are obsessively trying to pin on his political opponent introduces a layer of fatal hypocrisy. This is a strategic dividend for our rivals. The United States has historically relied upon its moral high ground, its perceived adherence to the rule of law and due process, to condemn the judicial abuses of autocratic regimes. When the president's own conduct is put on trial alongside his political vendetta, that high ground is obliterated. Our rivals can now dismiss all American condemnations of judicial overreach or political persecution as simple hypocrisy. By engaging in the very behavior it once decried, the U.S. legitimizes the worst practices of autocratic governance globally, sacrificing its ethical leadership for a personal feud. The repeated, unhinged determination to bring baseless charges that attempt to hound the accused through grand jury, after grand jury reaches a point where it transitions from prosecutorial overreach to a direct violation of the due process clause of the Constitution, the court's eventual necessity to intervene, arguing that the conduct constitutes a due process violation, is a legal expression of systemic crisis. Due process is the constitutional assurance of fairness. Its erosion confirms that the state's power is moving beyond all reasonable legal limits. This constitutional strain is not just a domestic issue. It is the most crucial sign of institutional failure to foreign observers. It signals that the American system is fundamentally broken at its highest level. The actions taken by the executive branch, the relentless pursuit, the misconduct, the defiance of norms are not confined to this single case. They set a fatal precedent that will inform all future domestic political conflict. The moment one side weaponizes the justice system, the other side is left with no option but to prepare for counter-escalation. This introduces a logic of guaranteed political warfare into the American legal framework. Every future administration will be tempted, and perhaps compelled, to use the full weight of the state's legal machinery against its predecessors and rivals, turning the judicial branch into a perpetual battleground. This internal war guarantees that the American state will be perpetually distracted, perpetually fragmented, and incapable of executing a unified, long-term grand strategy. The collective evidence of this case, the failed indictments, the unlawful appointments, the prosecutorial misconduct, And the constitutional strain is the terminal signal to the emerging multipolar world order. Our rivals do not see a system correcting itself. They see a system destroying itself. They see a great power that has become so obsessed with internal, self-inflicted wounds that it has effectively forfeited its claim to global leadership. The message is clear. America is no longer a reliable strategic competitor because it cannot reliably govern itself. This failure validates the narrative of autocratic states and accelerates the global drift toward a chaotic, less stable distribution of power. We are living through the final stage of a great power's decline, characterized by the ultimate act of self-immolation, the pursuit of political enemies through the deliberate corruption of the impartial justice system is a profound betrayal of the very principles that made the United States a global authority. The cost of this vindictiveness is measured not just in legal fees, but in the permanent loss of global credibility, the corrosion of institutional competence, and the creation of a strategic vacuum that our rivals are already filling. The internal war against the rule of law guarantees an external defeat. History will record this period not for America's external triumphs, but for the catastrophic moment when it chose the fleeting pleasure of political revenge over the enduring necessity of impartial justice.